First reading of Commission General Regulation 374, Archery Tackle, LCB file number R114-09. Rob Buonamici.
Good afternoon. For the record, Chief Game Warden Rob Buonamici. CGR 374 refers to two issues. One, the duty to pursue, retrieve wildlife. That section, that's a new section. Each person who wounds or otherwise injures any wildlife while hunting shall make a reasonable effort to take that wildlife, including without limitation pursuing and tracking it. Okay, this refers to all hunters, all wildlife, not just archery. And then on section 3, sub 3, we're adding an arrow that is used in hunting any game mammal or game bird may be equipped with a nock that is illuminated electronically or chemically. We've had several questions over time from archers. Hey, you know, they've got these illuminated nocks now. Can we use them? Without this language, they would be illegal. And this is just basically keeping pace with technology. Then the last section 4, sub 2, section D, we cleaned up the language with regards to chemical, explosive, electronic devices. So the new language would read, hunt any wildlife with an arrow that has any explosive, electronic tracking device, or poison attached. As used in this paragraph, poison means any substance that upon contact with the species of wildlife that is hunted is capable of causing injury, illness, or death. So with that, I'd be glad to answer any questions if there are any.
Commissioner McBeth.
Chief Rob, with regard to the wounding of wildlife and making the reasonable efforts, that applies to all hunting, right?
Correct.
It's not just archery.
Yes, that is correct.
And while I have absolutely no suggestions for how you could possibly change the language of this, I'm just curious what the department's thoughts are on trying to pursue, you know, somebody with regard to a violation here. Is it, I mean, are there some, I would assume it'd have to be some pretty egregious fact patterns that are going to result, because, I mean, this is, I can see this being attacked, you know, for being vague as to how do you make a reasonable effort?
Excellent question. With regards to reasonable, for example, the U.S. Federal Migratory Act, no person shall kill or cripple any migratory game bird pursuant to this part without making a reasonable effort to retrieve the bird. It's in federal law. It's a legal term used across the board. It's even applied to us in use of force situation as police officers. Must use reasonable force. It must be reasonable. So that is a legal standard that's out there. What a reasonable, prudent person would consider under the similar circumstances. So it's virtually impossible. Every situation in the hunting arena in particular is different. And to say you shall track your wounded wildlife for quarter mile, or, you know, or for 17 minutes or whatever, that's not reasonable. It's based on every situation. Every situation's different. And you're exactly right. It would be for the egregious stuff. It's for the shoot the 4 elk on one tag and walk away from 3 of them. It's for those type of incidents.
Hey, Rob, I have a question. Isn't that in the regulations now? Because you've written citations on people that have tracked animals and haven't found them. You've written citations on that.
No, we haven't. For waterfowl, we have.
No,
because
for big game.
For big game, no. We have not written citations. The only possibility there is to write a citation would be for wanton waste. If somebody shot an animal and knowingly did not track it, we'd have to prove knowingly, did not find it, knowingly left it, etc. This is designed for the person that shoots an animal, doesn't follow up the shot, makes no effort. We get those reports occasionally, but there's nothing we can do.
There's one, years ago, one case I remember, the guy tracked an elk for a long time and never found it. And he was written up for I don't know what. It was, you know.
If that's the case I'm thinking of, which I don't know if it is, but there was a case similar to that in White Pine County.
With a guide?
Yeah, there was a guide involved, and his client wounded I believe it was an elk. Things are a little fuzzy here, but I believe it was an elk. This was a few years back. And the client, they made a small effort, and the guide mentioned to the client that, hey, I think we'll find it tomorrow. You know, it's bleeding pretty good and all that. Client says, don't got time. I'm going back. I don't have any more time to look for it. And that elk was eventually found by the guide, I believe, and a wanton waste citation was issued to the hunter.
I can talk to that in later. I thought maybe this all ran there. Anybody, Commissioner Corbin?
Question for you. Why would you not have to fill out a form if you wounded an animal and didn't retrieve it and let the department know? If you were a hunter.
We aren't requiring to fill out a form.
Well, I know that, but I guess what I'm asking is that down the line, wouldn't we want to have that knowledge of that? You know, there were 80 animals which were shot, which were not retrieved.
That question, I believe, is still on our hunter questionnaire for wounding. Did you wound an animal? I mean, there are times, we all know that when hunters wound animals that it's not retrievable. They make a good faith effort, and you just don't find the animal.
Well,
but that happens.
Don, could you want to come up and answer that then?
I think I can just say it is on the website now, and Mike is changing the wording a bit, but it will still indicate whether it was an animal wounded as part of the harvest reporting. So if you hunt, you have an obligation to complete the harvest report, and one of the questions on it, whether you harvested or not, is did you wound the track?
Okay, thank you.
Commissioner Cavan?
Thank you, Mr. Chairman. Rob, it says reasonable effort to take that wildlife. Retrieve? I mean, the word take, it seems like we're trying to retrieve it at this point.
You're trying to retrieve it. The legal definition of take also includes
Retrieve.
Just
trying to make it easier for someone who doesn't know the legal definition to.
And a lot of it too is, you know, you're tracking wounded wildlife. It's still alive, and you may have to shoot it again. Okay, so that's not retrieving, that's taking.
I had another question on a nock that is illuminated electronically, you know, and you said keeping up with technology. Well, keeping up with technology is laser sights and everything else, but can you explain why a nock needs to be illuminated?
It's just the archery industry, the archers preference out there to retrieve their arrows. You know, you miss the animal, you can find your arrow a lot easier. You hit the animal, it's no secret that a lot of these animals are taken prior to the legal shooting hours, you know, 15 minutes, half hour before legal shooting hours, they wander off. And the hunter is tracking that animal in the dark. So this may help with that as well, to be able to, you know, make a reasonable effort to retrieve the animal. It helps.
Could I comment? Ken Mayer for the record. As an archer, I'm not an avid archer, but I do archery hunt. One of the things I'm finding as I get older, and I'm shooting 300 feet per second, I can't really tell sometimes if I hit them. But with a lighted nock, you can see it. In fact, I shot an animal one time, and he went clear through. I had no clue I had even hit it. Got down, walked over, couldn't find blood. Didn't give up. There was blood. So it's really it seems like a pretty good tool for knowing where your arrow actually went, especially in low light conditions, overcast, whatever. Especially with an old guy like me with.
You need a laser sight.
Well, I didn't need the laser sight to hit him, but once I let the arrow go, for the old geezer to know actually the arrow got to where I thought it was going. So.
Mr. Cavan, you're an archer. What do you think?
Well, it does get away from, you know, we've kept the muzzleloader thing as pure as possible, and they have huge advances in technology, and the archers have huge advances in technology, and we're letting them take advantage of essentially everything. But the opposite, I was thinking in terms of the opposite of what Rob mentioned. He's saying, yeah, they shoot in low light conditions. So we're giving them a chance to retrieve an illegal animal.
No, I was saying before legal shooting hours were up.
Or after.
Well, if they're doing it after, then we got ways to deal with that as well.
But I mean, so I have mixed. I don't have any heartburn over it, but just because it's an advance in technology doesn't mean that we have to adopt it. I guess it was.
Yeah, there's been requests from archers for this, and to us, it's immaterial. I mean, but as far as the pursuing wounded wildlife, we feel, you know, strong about that. That should be a given.
Commissioner Capurro?
Mr. Chairman, I watch the two hunting channels on cable and that, and watch them use those. It really does give them a good idea whether or not they hit the animals. So if they, you know, if you missed it altogether, then you aren't wasting a lot of time tracking something that's not wounded. Secondly, though, it's not going to help much with respect to retrieving it, because in most cases that arrow goes straight through and it's not retrievable. And it's retrievable in the grass, and you can see the nock at that point. But to me, I think it's a different situation regarding the use of that as opposed to the use of certain types of optical sighting devices.
Commissioner Rain?
Thank you, Mr. Chairman. One question on the first part about the person who warns. I mean, I don't know that anybody has any problem with the language, but how enforceable is that compared to the way it currently stands?
Right now, there is no provision.
But I mean, with this in there, can you enforce that? I mean,
Yes.
it would seem to be a very difficult fine line to enforce.
We do it for waterfall all the time.
I mean, you gotta give
For
me
ducks and geese.
I mean, the scenario. I mean, how are you going to enforce that? I mean, somebody just does not take one step towards the game animal. Where is that line? How is that line determined?
Like I said, it comes back to the definition of reasonable, which is used by the U.S. Supreme Court on a consistent basis. From, like I said, everything from officer-involved shootings to our use of force to you name it. It's in a lot of laws. You look at the other states, in the West, all those that have a duty to retrieve, duty to pursue type regulation all use the term reasonable. Reasonable is exactly what it says, reasonable. If I came before this commission or this group of sportsmen and said we had an individual that wounded a deer and he spent, 2 days following it, tracking it, and we wrote him a ticket because we felt he should have spent another half a day doing that, we'd be laughed out of here. That'd be ridiculous. And what we're looking at is the other extreme. Hunter wounds a deer, walks down there, sees blood, oh, it ran too far, I ain't gonna worry about that. And we actually interview folks, have statements to that effect, confirm that. I think most people in this room would say that person did not make a reasonable attempt to retrieve that deer. We do that with ducks and geese on a routine basis. They shoot them, they watch them fall, and they make no effort to retrieve.
What can you do if your office or your wardens don't actually see it happen? Can you take the testimony of some other hunters who saw them basically walk away from making any kind of attempt, inciting the individual under this law?
Yeah, it'd be like any other law on the books. We get a report from hunters that say, hey, we observed this happen.
Okay.
We usually, 9 times out of 10, we go interview the individual that they observed do whatever, and base the case on that. Most of the time, we'll get a confession, ultimately. So that clears that up. But there are times when the hunters that observe the illegal activity, they testify in court as to what they saw. And so the case has to be made that way. But most of the time, the investigation, bears out the facts. And there's usually some physical evidence that we attach to the case.
Not a felony, is it?
Yeah.
No, it's a misdemeanor.
Any other?
Yeah, one other comment, Chairman.
Commissioner Corwin?
In hunting extensively overseas, okay, with any animal that you shoot over there, okay, if you wound it, you pay the trophy fee, okay? The matter, and I realize that this would be very difficult to do here, that's not practical, but I do say that there is no such thing as reasonable. You hit the animal, it's your trophy fee. You either recover the animal or you've paid the fee, and there's no middle ground. So this whole term reasonable, okay, is really just so vague. It kind of troubles me when I look at this thing, okay, because as we've discussed here, what is reasonable? And there's really there's no guidelines. Should there be any guidelines under that term?
Well, with all due respect, that's kind of what our country is founded on. Other countries do not use the term reasonable. This country that's one of the premises, that we are reasonable people. We act and respond reasonably. So I offer that as a bit of an alternative to come up with a definition as to what reasonable actually is. Like I said, do you pursue it for an hour? Do you pursue it for 4 hours? Do you pursue it for so many miles? Each case is so different. And I mean, to even put a hunter in that spot, we might come up with, okay, you need to pursue it for at least an hour. Well, the hunter determines, and all the facts show, hey, that animal's going to live. I mean, you wound a dove, and the dove keeps flying. Well, you didn't pursue it for an hour. You got a regulation that says you got to pursue it for an hour. We're writing you a ticket. I I can't support that. I think we do need to be reasonable. I think the public expects game wardens to be reasonable. I think the public expects, fellow hunters to be reasonable. And it's a standard used from the lowest court to the highest court in the United States.
Rob, what's your experience about in the court when you have these kind of things? What do you get beat up on? And what makes a case and what gets cases thrown out?
What makes cases is, this is totally different than there's a vagueness issue. If it's too vague, it's unconstitutional. Well, again, the courts have determined reasonable, and the courts look at it. Every case, even if it's pretty cut and dry, they keep falling back to, was it reasonable? Did he have his fishing license in possession? No, but he had it on the rock next to him. Well, we write that ticket. The court's going to go, that's not reasonable. So, again, if we put concrete terms, and we like to do that whenever we can, but there are times when it just, at least I don't see how we can apply some concrete language without the term reasonable. I mean, this isn't like, the limit on chucker is 6. No, the limit is reasonable. That's two different things there.
Commissioner Cavan?
Thank you, Mr. Chairman. So, Rob, you're writing tickets, or you have the ability to write a ticket now for waterfowl,
Yes. And we do.
and is that under the federal regs, or is
Yes,
that?
under
okay.
federal.
So this would be any wildlife, so right now the only thing you can do is waterfowl.
Yeah, right now, we can
So
write a
this-
ticket if somebody does not make a reasonable attempt to retrieve a mallard. But we can't write a ticket if somebody doesn't make a reasonable attempt to retrieve an elk.
It wouldn't be wanton waste?
Depends if it dies or what the deal, what the situation is, where it dies, who finds it, if it's found.
Okay, let's turn this over for public comment on this, and if you want to just stand by, would you? I need some answers. Thank you.
Brandon 14. I want to start with the illuminated nock. In that respect, I'm an archer. I hunt muzzleloader, I hunt rifle, all weapons. If it was an advancement, like Tom was saying, where archers have bows now going 350 feet per second, I'd say that's a bad thing. But with the nock, it's not changing the ability of getting it. It's not giving you more speed to your arrow or this or that. It's changing nothing but watching where your arrow hits. And in that, I would hope you guys understand that I would really support this, that you can see if you hit the animal or not, so they know whether to go after it or not. Just like the director said on his, that he didn't think he hit it, didn't find blood, but he kept looking, and pretty soon he found the animal. This gives a clear mark to see what you hit, is all that's doing. And then on the other aspect, as far as the reasonable looking for game, I personally witnessed several people hit animals and think they did not, because they didn't go and check. And I think there should be a law out there that people should have to go and check whether they have wounded animals or not. Just something a little bit more. Thanks.
That's my idea, is just because you have illuminated knock on the thing, that doesn't guarantee you're going to know if you hit the arrow, because, if you might shoot and say, well, I missed him, and you might have hit him. And, I think everyone that shoots an animal, should go look and see, even with a rifle hunter, should go look for blood, and it might decrease some of the archers from going out and looking, and they're shooting a lot closer range than a rifle hunter is. You're shooting at 50, 75 yards, and if you're not sure, then you'd go look for blood, and, you'd retrieve more animals that way, and I think everyone should, but I think it'd be a sort of an excuse where they say, well, my illumination, I look down there and I there's no guarantee they're going to be able to see exactly where that went, so.
In one instance, I see where you're going, but I personally don't think that would deter anybody from going and looking. Most archers now hunt with color of veins or feathers so they can see it. They hunt with color of nocks so they can see the arrow flight. It's just giving you an aid. And I personally don't hunt with it, but when that come up, I really thought that was a good idea. And I've seen them, and you can watch that path really well.
I'd hope they'd still go look to see.
Oh, of course, absolutely, they should. Yeah.
Okay, thank you. Anybody else? Go ahead.
Donald, for the record, speaking for myself, a prudent person, if there was, it might be two different things for two different people. Like a man had a bad heart and the deer went up and he had a good idea it was up there, but he knew he would die from a heart attack going up there. A prudent person wouldn't climb that mountain with that type of a situation. But a young man that was good and healthy, you know, he would climb that mountain. So the animal could be, it would depend on the person. And it's up to the judge and the game warden to decide what is prudent. Because it would be a man in a wheelchair can still go hunting. And if the animal goes down over something that it's impossible for the guy to get to, and he makes an attempt to go over there and he just can't go any further, but somebody else could walk down there, but there was nobody to help him. It's what a prudent person would do.
Chairman, can I just follow up a question with him? And I want Rob to, because this is a good fact pattern of trying to demonstrate what reasonable is. In that situation where you have somebody who is not capable of climbing, okay, that in my mind doesn't necessarily mean that that's the end of it. Okay, what's reasonable under those circumstances is for that person to then get somebody involved that can make the attempt to get up there to find out if there's blood or, you know, so reasonable means reasonable under the circumstances. So we have to take into account the circumstances of that particular person who made the shot. And so I think that's what reasonable is you have to really take into account fact patterns like this.
Any other comments on public? Go ahead.
Thank you, Mr. Chairman. For the record, Thomas Wilson, Washington County Advisory Board. Commissioner McBeth, you're absolutely correct. And let me preface this by starting off by saying that for many years I was a deputy district attorney here in Washoe County, and in that capacity my role was to prosecute all cases submitted to the district attorney's office by the Department of Wildlife. And I've actually, on other issues, I've worked with Chief Buonamici on some of the language and I understand the trepidation with the term reasonable. In most law, the reasonable prudent person standard is a language that you find in civil law or in common law. You find it in torts, you find it in contracts, you find it in other civil cases. Does it cross over to criminal law? The answer is yes, it does. The probably easiest explanation would be self-defense. You have to be in reasonable apprehension of immediate harm. So what is reasonable under the circumstances? The reality is what's reasonable under the circumstances is what a jury's going to tell you it is, because they're the ultimate trier of fact in any particular case. Is it going to be void for vagueness? I share your concern, but in my experience, this would not be void for vagueness at all, even in the realm of a criminal activity. As part of the advisory board, we looked at this. We think it's a fantastic idea. We had a little bit of changing to the language, which I think is relatively minor. The words wounds and injures is redundant. It's pretty hard to wound something without injuring it. It's pretty hard to injure something without wounding it. What the idea is basically say, look, if you shoot an animal, you've got to make a reasonable effort to recover it, to obtain it. So we struck those words and inserted the word shoot. So it reads, each person who shoots any wildlife while hunting. The other reason we inserted the word shoot as opposed to wounds or injures, and this is going to sound a little far-fetched, but when you're dealing in criminal law, you have to anticipate the absolutely unforeseeable. Say you're walking up on the high country and you start a small landslide, and the small landslide goes down, and at the bottom of the canyon you injure a deer. You didn't shoot the deer, but you did create circumstances which injured wildlife. Technically, the way it's written, you're going to have to go after that wildlife, even though it may or may not be one that you have a tag for. So we changed the words to shoot. In reference to the term to take, we changed that to recover. So under our changing of the words, each person who shoots any wildlife while hunting shall make a reasonable effort to recover that wildlife, including without limitation pursuing and tracking it. I think that's clear. I think it's clean. I think the intent is pretty straightforward. The only type of hunting I think that this would not be applicable to, and I don't know how to write it so it would be falconry, because you obviously don't shoot something when you're hunting with a falcon.
Do you consider that
Commissioner Caput?
you consider that in law using the term shoot would also cover archery?
Yes. Because that's what you do when you, and I am an archer as well.
I said in law. I'm not talking about
No,
what we
because you
normally
shoot a
would
bow and you shoot a gun. So as opposed to starting a landslide that injures, something, and I didn't want to put in the term intentionally, because that opens up, in the field of criminal law, that opens up an entirely different avenue. Or I intended to shoot this buck, but I shot that doe. Well, if I didn't intend to shoot it, then I don't have to go track it. Well, we don't obviously want that situation either. But shoot, I think, would apply to archery as well as to rifle.
Well, my concern is that it might to you, but I want to make sure that some judge, because, there are a lot of things that reasonable means something in law to a judge and to a prosecutor and the defending lawyer, but shoot, I'm not so sure that that's a common term with respect to that a judge would consider as being specific enough to cover it.
Well, respectable minds can disagree, I suppose. It's been my experience that the term shoot would cover it, because any defendant who's brought before a judge in a court of law under this statute, at least under the idea of what the statute should be, is going to be a hunter. And that person will have been out in the field, hopefully with a tag, or they'll be faced with different crimes, with a gun or with a bow, and would be shooting an animal. So in my experience, I think that term would work. I know it's very pedestrian, shoot, as opposed to something else. But sometimes the clearer the language, the better it is for people to understand it. I want to make one more point that was made about how would the department prove in a court of law whether or not do we need other witnesses? And the reality is yes. You would have to have you would either have to have eyewitness testimony from a game warden, which probably would rarely happen, or eyewitness testimony from another hunter in the field, in order to build the case beyond a reasonable doubt. And I say eyewitness testimony because if all you have is a hunter who goes to the department and says, yes, well, I wounded a buck and I didn't look for it. Well, that would violate the corpus delicti rule, and there would not be any conviction after that. The corpus delicti rule basically says that you cannot convict somebody based solely on their admission. There has to be independent corroborating evidence of the crime other than their admission. So you're gonna almost in every situation gonna have to have some type of eyewitness testimony, either from a game warden or from a fellow hunter in that party, or for somebody who was out there who actually witnessed the person do the shooting.
So are you saying the only change you would make is change the word wounds to shoot?
The changes that the Washington County Advisory Board made were omit the words wounds or otherwise injures, because, like I said, it's redundant, and it also takes away the actual hunting activity and includes other activity that has nothing to do with hunting, and insert the term shoots. So each person who shoots any wildlife while hunting shall make a reasonable effort. So we wanted to focus it on, get away from the rock slides and things like that, and focus it just on, if you shoot an animal, you need to go get it. You need to try to go get it.
Commissioner Macbeth?
Tom,
Yeah.
first of all, I absolutely respect your background, and because I am not a criminal attorney by any means. in my mind, the word shoots almost dictates that if there's any shot taken at a game, that you actually have to go over and make a determination of whether, because a lot of times we shoot, we don't even know if we've hit.
Right.
Okay, and we've been surprised many times when you go over and there is blood and hair and everything else, but you didn't hear the whop, you didn't hear anything else, and you didn't see anything, and yet, you know, just as a matter of ethics, when I shoot, I always, you know, not only go over to the spot where the animal is, I pick up tracks and I make an absolute determination in my mind, so I can go to bed that night, that I have not left a wounded animal out. But so are we advocating that we have to, we're setting a standard to where we have to follow up every single shot, or is the way it's written require us to have it not only shot but seen some evidence that we seen or heard some evidence that we've hit the animal, injured it and wounded it?
The way this is written, my interpretation of this regulation, should it be enacted, the way it is written requires a hunter to take reasonable steps once they know that they have hit the animal. If they don't know that they've hit the animal, there's no obligation under the law to take any steps, which you could also argue is a factor in favor of the illuminated nocks, because how many archers have done the first thing? You go out to the spot where the deer was standing, you look for your arrow to see if there's blood on it. If you can find your arrow, pretty good indication you're going to know whether or not you wounded the animal or not. If the idea behind the regulation is to impose a standard in which, look, if you take a shot at an animal, you need to go make a reasonable effort to determine if you've hit it, then we can change the language that says every person who attempts to shoot, or who attempts to, not attempts to shoot, but any person who attempts to harvest in accordance with their tag must make reasonable efforts to determine A, if they've hit the animal, and B, if so, to recover it. I mean, that's easy language to put in, but that's setting a different standard. The way it's written now, by the way I read it, is once you know that you've hit the animal, you must take reasonable steps to recover it, but it does not impose any affirmative requirement for you to take reasonable steps to determine if you've even hit the animal. And it's a fantastic question. And I suppose one question that this board needs to determine is, where do we want to go? Do we want to make a reasonable, a requirement that you take reasonable steps to find out if you've injured the animal, or just to impose the reasonableness requirements after you know you've injured the animal? It's a great question.
Tom, the term reasonable seems like the term normal to me, okay? Everyone seems normal until you get to know them. So,
reasonable,
I'll leave it at that.
Reasonable is a very difficult legal standard. In law school, it was the reasonable prudent person standard, and the big joke was, well, we know what that was if we could ever find a reasonably prudent person, because there's no such animal. The reality is, whenever we're trying to create law, we have to put a standard out there, and it's difficult to do it in every situation. So legally, we've come up with this fiction of the reasonable prudent person, and we'll be the first to admit there's no such animal. There is no reasonably prudent person, but have to do the best we can under the circumstances. And the ultimate safeguard is the jury is the one who determines, as the trier of fact, the jury is the one who determines whether or not it was reasonable under the circumstances. Great example is if you've got somebody in a wheelchair who wounds an animal, the jury may very well say, you know what, the reasonable prudent person standard in that wheelchair is you need to go find somebody to go up and look for your animal, because you can't do it now. And that's what's reasonable under the circumstances. A jury may very well determine that.
Commissioner Capro?
Yeah, I hate to keep talking about this, but what would happen if you change that language the way it is here and simply said each person who shoots any wildlife while hunting shall make a reasonable attempt to attend? What about if I hit one with my truck and I have a tag for deer, it's a deer I strike, don't I have some responsibility? And he doesn't just fall dead right there. Don't I have some responsibility to track that one? I think that's why the language or otherwise injures wildlife is in here.
Sure. And that scenario came up when we were rewriting a different law. Nevada, of course, unless we've changed it, Rob, and I don't think we have, Nevada does not have a kill and grill statute. And I'm speaking the vernacular. Kill and grill means that if you hit it with your car, it's yours. Have fun, fire at the barbecue. In Nevada, if you kill an animal with your car, I believe you're under order, not under orders, but the law says you have to report the animal to NDOW.
No, you just can't possess it.
You just can't possess. Oh, you don't even have to call it in. So, should you make a reasonable effort to retrieve that animal? I think ethically the answer is sure. Does that happen, and would that also apply to little old lady Granny who hits a deer with her car?
This says while hunting.
While hunting. So in this one, well, okay. So if you hit an animal with your car while you're out hunting,
Tag it.
yeah, I love criminal law. The way it's written right now, without any revisions, would you have an affirmative obligation to go out and try to recover it? The answer is yes, you would.
Yes, you would.
Just like creating a landslide.
But what you're doing, if you take the language out as you're suggesting, you would.
That's correct. That's correct.
Okay.
That would be absolutely correct.
Any other public comment on this? This is, go ahead. This is just the first reading, so it's only information. And we'd like to keep moving on.
Gil Yannick, Carson Advisory Board, we thought the issue with illuminated nock was a great idea. And you've all beat to death the reasonableness, and we felt as long as everybody understands, and particularly the game wardens understand, and then of course, as was just mentioned, the trier of fact is are the ones who make the final decision whether the effort was reasonable or not, and we're happy with that.
You think we should add as directed by a reasonable game warden?
We'd like to, but I think that everyone that we've met is always reasonable.
Thank you.
Man.
Rob, you want to come back up and address just some of those language changes real quick?
Again, for the record, Rob Buonamici, Chief Game Warden. With regards to the language on the wounding or injuring, I suggest we blend two good ideas. It is a good idea to have shoot in there. So maybe something along the lines of each person who shoots and wounds. So you got to shoot and wound the animal.
Just so it's not the one and the same, shoots and wounds. Because that doesn't take care of the guy.
Well, that clears up the question, if you shoot and miss, or the landslide, or those type of issues. You shoot at a deer, you miss it, there is no duty there. You shoot at a deer, you wound it, then there is some responsibility placed on the hunter. And I think that might, blend those two good ideas.
Commissioner Rain?
Thank you, Mr. Chairman. How do you uniformly enforce this? How do you go about going to your game wardens and making sure that this is uniformly enforced so that, everybody isn't treated differently? It's got to be a tough... Because there's so much standards, Everything is...
We do that. Any enforcement agency has the challenge of uniformly enforcing something. For example, just keep it real simple here, something everybody can relate to. Highway patrol, speed limit's 55. Well, writing them for 56 and a 55. Is that reasonable? Got the radar. It's right. There's no doubt. It's 56. It's not 55. Is that reasonable? So what we try and do in our division is we have annual in-service training sessions, and we instill a common philosophy amongst skateboards. Each situation is going to be different. I mean, there's no question about it. They may sound the same on the surface, but each situation is different. So the common philosophy, the common thought process is what's critical there. So given that Hunter A out of Las Vegas is contacted by a game warden down there, and should that same identical set of circumstances occur up out of Elko, game warden B up in Elko will handle the case very similar.
I know this is covered a lot in hunter's education, goes a lot into what you need to do, what is ethics. And that's why, you're enforcing ethics. That's why I'm asking, it seems tough to enforce ethics. But I guess in this case, there's sufficient.
I mean, we have these discussions that have occurred here. I mean, we have them at our in-service. Okay, what's reasonable? We have new people coming on, and some haven't hunted. So we've got to, go over that, and that's our responsibility, but, reasonable is a common standard. And it's, like you've heard, it's throughout case law.
Commissioner McBeth?
And, it just came to me that actually in every single thing that you do as a law enforcement officer, you deal with reasonable, because you have to determine reasonable cause to basically do just about anything that you do from a law enforcement standpoint. So the term reasonable really is a term of art that law enforcement has, literally hundreds of years, behind it. So in that respect, law enforcement of all agencies probably knows the term reasonable better than anybody else.
Yeah, we're judged on that. I mean, something as serious as having to take a human life, we're judged on that. Was it reasonable? I mean, so if we're judged on, in those scenarios, on reasonable, I would submit that we're capable of being judged on something like this, under the reasonable standard.
If you want to make any change in it for tomorrow, go ahead and do that, from what you heard here. We'll take another shot at it tomorrow. Okay, thank you.
Right, thank you.
Let's move on to next item of business, Commission General Regulation 377, Americans with Disabilities Muzzleloader, LCB file number R138-09. Kim Jolly.
Kim Jolly, Management Analyst 3 for the record, and good afternoon, Commissioners. Commission General Regulation 377 is the language that will provide a reasonable accommodation as required by the Americans with Disabilities Act, or the ADA. As you know, the U.S. Fish and Wildlife Service ruled that state wildlife agencies with muzzleloader-only seasons that did not provide reasonable accommodations to persons with visual disabilities were discriminating because those persons would not have equal access to the muzzleloader program. And our legal counsel has wisely advised us that we must go forward and provide a reasonable accommodation in order to not jeopardize federal funding. The regulation before you, as you know, was developed after many, many months, starting in June of 2008 with my part. Previously, my predecessor started it back in 2006. Developed after months of discussing this issue and gathering feedback from other states, county advisory boards, you, the commissioners, the public, and muzzleloader groups. This is the strictest language that we could develop based on the Colorado and Minnesota language that exists now, that the Wildlife Service would agree that would provide a reasonable accommodation under the ADA. It allows only a one-powered non-magnifying scope for those who apply on a form that we develop, and only if they qualify. Only persons with a visual disability certified by a physician and which substantially limits a major life activity would qualify. Even more strict than Colorado, this permit you have before you would only be valid for 1 year, so any applicant would have to reapply every year. As far as implementation goes, from this point forward, after a regulation is approved by the various steps to implement it, law enforcement would be implementing it and help me develop a form, and it would only be available at headquarters, not licensed agents, as you can see. And then those law enforcement officers would be able to ask for any additional information from the applicant, and that provides us maximum flexibility. So you all have the frequently asked questions piece in your packets, and it's basically the same one that we've had for a couple of months with a little bit of edits there. And it explains many of the questions that we've presented before, but please let me know if you have any other questions.
Chairman?
Any questions? Who wants to go first? Commissioner Capurro?
Yeah, I've got several questions. Number one, have they actually filed suit against any of these jurisdictions that didn't respond right away to doing this? Because in order to take away the federal funds, they'd have to have some sort of a...
No one has refused to do it, if that's the question. Every state that was originally in the discrimination.
I think your statement is incorrect. Most federal legislation, I haven't reviewed this specifically, but most of it is contingent on compliance with the Americans with Disabilities Act. So, no, they would not have to file suit before cutting off funding.
I guess the question becomes what is, and this reaches the heart of what I'm trying to get to. But number one, restrict it to muzzleloaders. Now, what's to prevent it from them from coming back and saying, well, you're still discriminating against us. Why can't we do this in a rifle season? Mm-hmm. So are you going to issue a license to hunt in a muzzleloader season for someone that you couldn't issue a license to or a tag to for a regular hunt season? Is that what this does? Mm-hmm. The answer is yes, right?
I don't understand your question.
In other words, it's restricted to muzzleloaders.
Correct.
So you would be issuing, if they met these standards, you would be issuing a tag to someone that met these requirements for muzzleloading only.
This is for a permit.
They would not qualify for permit.
This is just a permit after they already qualify with a hunting license. Okay. So
I understand that, but the point is still that you would prevent the same person from hunting with any weapons in an any weapon season.
No, I don't see how that
this.
Well, yeah, you have
Anybody
scope,
can use
but
a scope on a regular.
you issue, the only circumstance you have in law right now is you issue a permit to someone who is legally blind, and they must have someone with them to shoot. Mm-hmm. What we're talking about doing now, no offense to disabled people or anything, but in accordance with this, if they had diabetic retinopathy, traumatic brain injury with double vision, and there were some comments in some of the CAB meetings that questioned hunting on the same mountain, that you'd have somebody that can't see from here to here. Mm-hmm. But we're going to issue them a permit to use a 1-power scope, which doesn't magnify anything.
There is a lot of burden on the physician who would sign or certify that this person would, with a scope permit, be able to safely hunt. If the physician deems that they aren't safe to hunt even with a scope, then if they were to submit something certifying that, there's other regulations that we could go after the physician for being negligent and fraudulently certifying that statement.
Could I also, I think for clarification, a person that has these visual impairments can still get a hunting license. They can still get a tag. And then it's up to them whether they think they can see through a peep or not. And what this permit does is says that they can use a 1-power scope on their muzzleloader during the muzzleloader season where the scopes are not allowed. So it doesn't preclude, people from getting those tags now.
Well, the way your definition is, by the answer that's given in the thing here, it basically includes legal blindness too.
I think somebody that's legally blind can
with
still get a
over
license and a
2200
tag.
Vision.
My point is that if you're legally blind, you can still get a license and a tag.
Which, to me, that's a concern. there are some things that I don't that discrimination is not an issue because they simply are not equipped to be able to safely perform the types of either acts or the like to the non-detriment of other people that are in their vicinity. And to issue a tag and a permit to a legally blind person, I can see it if he's got someone who's going to shoot it for him. I cannot see it if you're going to issue that same permit using the definition of legal blindness and let him shoot it.
I guess the question would be then to the two DAGs, is that a separate issue that needs to be addressed by the commission that would then, if this issue is about whether somebody with this affliction that gets signed off can get a permit to put a scope on the rifle, the thing that Commissioner Capurro is talking about is, in general, should we look at eliminating the ability of a person that's legally blind to even get a hunting license?
Well, I don't mind him getting a license and a permit so long as somebody else is designated to fill that shoot form. We do that already now.
Mm-hmm.
I think what we ought to do is extend this sort of thing with these visual disabilities that are defined here to include legal blindness, the way this reads, to do the same thing, rather than give him a license to hunt. I don't know, is anybody here comfortable with being out in the hills with a guy who has a traumatic brain injury?
If I can just make one,
Double vision?
Let's have-
okay, go ahead.
Let's
Sorry.
have our legal.
The problem here, Commissioner Capurro, is you're going far beyond the mark that we're trying to hit today. What the Americans with Disabilities Act is about is a person with a disability that affects a major life function, if they can still carry out an activity with a reasonable accommodation, then you have to make that reasonable accommodation. And so this only affects the category of people who are visually impaired but can safely hunt with this accommodation. And this, I don't think right now, if you want to propose that kind of change for the future, that's fine. But this change is focused on a reasonable accommodation for people who can safely hunt with this, you can argue whether it's a small accommodation or a big accommodation, but the authorities have determined it's a reasonable accommodation. So we're only focused, this is focused on that one category, and it goes beyond the scope of this agenda item to want to change the law and the Americans with Disability Act we're bound by that. It's a federal law, so we're stuck with that. And this is the reasonable accommodation that helps these people in this particular group. And so I guess your point is well taken, but it's an issue for another day.
I'm going to ask the legal. How do you know a 1x magnification is going to solve the problem? How do you know that's going to work? 1x. Why isn't it 2 or 3 or 4? Who makes that determination? 1x doesn't do anything.
Well, but again, you're only talking about this narrow class of persons who can be assisted with this 1x. Then, let's say there's another group of people that's come in and say, well, with 2x, I could hunt. Well, then you have to decide whether it's reasonable. Again, the word reasonable, and that's the standard. I mean, that's the standard the Congress set, a reasonable accommodation. And where you draw that line, you have to figure out on a case-by-case basis. But what the authorities have talked about in this particular case is that there's this narrow class of people who can be accommodated with a 1x scope, and whoever decided that 1x is not, doesn't violate the spirit of the muzzleloader activity, I guess you call it. And so that's what we're addressing here. Is 2x reasonable? Well, the whole point of a muzzleloader is to get back to that primitive hunting experience, I think we call it normally. So is it reasonable to allow that? Maybe not. But this 1x has been found to be reasonable, so.
It has.
By the federal government, yeah.
The other point I want to make on section 4, the definition of visual disability, it is not correctable with glass or contact lenses. Well, you should put it, or surgery in there. Somebody with cataracts can't be corrected, but surgery could correct it. Keratoconus can be corrected with surgery and not with contact lenses, and so there's other things that can be corrected with surgery, and they should be in there too.
We were trying to keep the legal definition under the ADA so that they accepted our minimum change to meet their minimum requirements. So we were trying to stay with their definition.
A lot of things can be corrected with surgery if people don't do it, like cataracts, and that's very easy to correct, and that'd make them where they wouldn't need that.
I think someone with cataracts, if they don't qualify under that limits a major life activity, then they wouldn't be in that narrow range anyway. So it has to be the visual disability definition and substantially limits their major life activity. So that narrows down that group a lot.
Mr. Chairman.
Commissioner Corbin?
Kim, what's next? We're going to put Braille on these guns? I mean, seriously. I mean, we're dealing with a Disabilities Act here.
No one likes this, and none of the states, especially the western states, like this idea. They don't like the slippery slope or the trend. What we're trying to do is just meet our obligations under the ADA. And I mean, we met with I made presentations to the Eagle Valley muzzleloaders and the Eagle Valley, or the Lakes Crossing muzzleloaders, and they have the same questions you do. They know that the group that started this discrimination suit, but they understand our situation. They completely understand. So, and they support it. So we're just trying to meet our obligations.
Then we might go back into a one-draw system for rifle muzzleloaders, put everybody in the same one, and to keep the odds the same, and draw everybody together then if we're going to be in the same boat.
Mr. Chairman, sorry, one more point.
Mr. Cabrera.
Going back to the previous discussion we had on the other regulation, then, I presume that these people could hunt by themselves, and not with somebody to shoot for them. So they're going to be subject to the same regulation that we're talking about retrieval, right?
How other states have dealt with that, Minnesota and Colorado, and this is how we hope to develop our application form, is they have a whole page of how do you expect to retrieve any animal that you take or that you injure, and they go through each type of disability and whether they designate another person to come with them, what have you. So those kinds of issues, we didn't put every single thing in this regulation, because sometimes the more things you put in the regulation, the more you box yourself in, but we are going to address, or law enforcement is going to address those in the implementation phase.
Commissioner Rain?
Thank you, Mr. Chairman. We're looking at this narrow category of people that this applies to. It appears that it is so narrow that it applies to no one, because
That's good.
due to the
That's the
fact
idea.
which is not reasonable. You want to put it that way, that a court would be issuing that. Therefore, we are issuing a regulation that serves no purpose and no person. In order to fulfill a federal requirement of some sort, and that falls under the "this is not reasonable" category, which falls. So what are our options here? If we dump this, say this is not reasonable, what's our option? What happens?
You lose federal funding. You get no money from the feds.
Is that guaranteed, or 10% or 2%?
I don't know the specifics, but I know most of the federal funds I deal with, if you violate the ADA, you lose your money.
Is this a final determination? They can implement it tomorrow type deal?
We're like one of the last states to do this.
We are the last.
Everyone else has said, this is the lowest level of accommodation.
This is a nutcase situation.
Well,
I mean,
we
it
don't
applies
like
to no
either.
one.
No, it doesn't
nuts.
apply to no one. There's obviously someone it applies to.
Yeah, there's Toby guy that makes it.
Well,
He
see,
may-
Toby
He
can wear
doesn't
glasses, and that's his accommodation. He wants, the bottom line is where this all started, they want muzzleloaders with scopes on all muzzleloader seasons. That's where Tony
Yeah.
Bridges is coming from. Tony then filed a lawsuit trying to crack the egg, if you will, and so they disallowed his ADA claim, but they did say, the federal government said, but you haven't accommodated when you could accommodate, and that's the lowest common denominator is what you see here. And then we got a threatening letter from the service said, we thought this was going to be taken care of, tell us what the status is, and we were able to buy some more time because if you recall, I said that this got hung up with the Legislative Council Bureau and whatnot. So I think we're the last.
Hey, we're gonna lump
Yeah.
the season together with rifle hunters, then that's gonna be another agenda item, right?
That'd resolve the issue.
This is, we're trying to find a reasonable accommodation that, like we said, that doesn't affect all that many people. It's been accepted in other states. The feds have accepted it, so we can just move on.
Well, we got some muzzleloaders in the audience. We'll stick around, Kim. We'll turn over to the public now to comment on it.
Brandon 14 again. Listen to this. I think we're just making a big issue out of something real little, in my personal opinion. What you stated over and over again, that it's such a small percentage of people. Why we make it such a big issue? We have to accommodate them. We accommodate them and move on. We don't need to lump seasons together for one person getting a permit. I just think we're making a huge issue out of nothing. It needs to be accommodated. We accommodate them and move to the next thing that matters.
Wade 14 from Elko for the record, and I am a muzzleloader hunter. I'm totally against scopes on muzzleloaders, but I do realize the fine print and the things we gotta do for the people with disabilities, and this is just a simple thing that other states have had to follow suit with, and I realize state of Nevada, we have to go along with this. There's no way out. We just need to pass it. It's one power. The ADA, there's rules and laws that, as the Deputy Attorney General said, that we gotta follow. And we may as well just pass it and go on.
Do you use a muzzleloader with a scope in the rifle season?
No, it's not allowed in the state of Nevada.
It's allowed.
As I said, I am against scopes on muzzleloaders. That would take away from the reason why I hunt with a muzzleloader to start with.
Thank you.
You bet.
Next.
I'm Dan Hines from Lakes Crossing Muzzleloaders here in Reno, and I guess I have a question for Kim. She made a good presentation to us, and she expressed our concerns accurately, but at that time, I thought it very specifically said age, loss of depth of field was not a disability, and you didn't say anything to that effect. Have we got that covered? That's where Ken just said that's really where this all came from. And so we really don't want to leave that as an opening to be called a disability.
And he's totally right that I think in one of the questions in the FAQs piece, basically if your physician certifies it as a visual disability, that is a much more technical term than just someone who has aging eyes and can still carry out major life activities. So that was one of the, I said, just because you have aging eyes, like the Toby Bridges fellow who filed the complaint, that doesn't necessarily mean you're visually disabled.
Next.
For the record, Paul Dixon, Clark County. Just to say that we at Clark County had a discussion, and it was a 4-to-1 vote. I think we heard a lot of debate like you guys did, but I think the thing that really helped us, and I don't see her sitting in the audience now, is Kim Jolly got telephonically on the phone and spent a half an hour with us.
Behind you.
Right here.
What's that?
If it was a snake, she'd get you.
Just misplaced you. She got on the phone and talked with us. I'm sorry. I looked back because you were sitting back there. That's okay.
Yeah, we got another disability going on here.
You're eligible. Issue this guy a permit.
Synapses.
But what I did want to say is that was extremely helpful to my board and helped working through some of the questions that you guys are discussing up here. And I want to thank Secretary Mayer and you for being on the phone and doing that for us, because I think it's very helpful. And I would recommend on some of these things, either having the person there in person or telephonically really worked extremely well to try to get across the facts and to get questions answered, because people really do have a purist belief on things, but I have, working for the federal government for now over 20 years, can tell you the ADA Act, as pointed out by Deputy Attorney General Brian Stockman, if you don't follow that, they will nail you in so many places. I mean, we've had to make so many accommodations in federal buildings to allow so many different things in order to maintain federal funding. And to be honest with you, I think we've done an excellent job at putting something together which has been accepted as a minimum requirement out there. And because it's a minimum requirement, and as Scott said, it doesn't apply to anybody, well, it does. I mean, 9 people over 9 years in Colorado have met this criteria. A lot more have applied. My guess in Nevada, you're going to have less than a handful over a long period of time that actually can qualify for this. And therefore, you've met your ADA, you keep your federal funding, which for this group, I mean, I don't know what the loss of federal funding would be, Ken, but how much a year?
Well, on the PR side, Patrick, I think it was more than $5 million. And it could affect the DJ, which is equivalent to or more.
So our Heritage Fund equivalent in funding, we're going to lose because we're worried about things. I think we've done the minimum standard here, and I think we need to just move on. As pointed out earlier, this is we've gotten to a point that is the minimum, and we should move on. Thank you.
For the record, Thomas Wilson, Washington County. Well, I don't think I can top that. He said almost exactly what I was going to say. As repugnant as this general topic is to all of us, the attorneys have said this is a change that we need to make. And speaking as an attorney, and I'm sure the attorneys behind the table will say the same thing, we hate it when clients don't take our advice. All it does is make more work for the attorneys. This is an accommodation that we do need to do in order to maintain our funding. And I also want to publicly commend Kim. She came to the game board meeting, answered a lot of questions, and most especially the amount of research that she's done to give us the most restrictive solution while still being safe under the ADA, I think is where everybody wants to be. And Kim, I thank you publicly for doing that. I think you did an absolutely fantastic job on this issue, and Washington County recommends that we approve it.
For the record, Bill Miller, White Pine County. I too want to thank Kim for the preparation and effort that she's put into this. We've had discussions on the phone. We had quite a contentious county advisory board meeting on this issue. It's come up for so many years in the past. It's kind of like somebody rattled the cage on the chicken coop because it got pretty hot. We had some members of the audience who were muzzleloaders who were opposed to this. They also had some background dealing with ADA, and they felt that this was not either the scope or the intent of ADA, and no pun intended when I say scope, for the government to accommodate people with this type of a disability. We felt that we would stand our ground like we have in the past and oppose all scopes on muzzleloaders.
Thank you.
Kim's behind you.
Hi, Kim. Gil Yannick, Carson Advisory Board. Yes, we had similar discussions to what you all had this evening. In the end, we said that we bowed to the federal government and the pressure that they brought to bear and the fairness for those with visual disabilities. We voted in favor of providing this accommodation to them. Thank you.
Next.
Marshall Goldie. As I see it, it boils down to one fact: funds. If you want to keep your federal funds, pass the act. If you want to stick your finger in the federal eye and lose your funds and be on the forefront in this country for states' rights, don't pass it. But it's totally up to you. If you stick your finger in the federal's eye and say, no, we're not going to do this, go someplace else for your funds because you won't get them. And that's what it boils down to, is funds.
You're last.
Jerry Lowry, Washoe County, representing myself. I'd like to agree with the last gentleman that spoke. I think that that the unreasonableness of this act, substantially limit one or more major life activities. I think there's a difference between needing to have a stall back there where you can take a crap or being able to go hunting in the muzzleloader season. We're not restricting hunting in this state. We're restricting them from hunting with a scope during muzzleloader season. There are hunts that that accommodate that. So I think by the federal government giving us this unreasonable requirement, I think would be a good place to make a stand with states' rights. I know it may not be the thing that we want to spend our money on, but it might be time. This is really not about the ADA, because if it were about ADA, they would have included archery in their requirements. So there's another unreasonableness of the federal government. They're going to say you can hunt with a muzzleloader with a scope, but you cannot hunt with a bow with a scope. So I think there's some reasonableness of the government, and so that's my recommendation. Is to I think it's time. Thank you.
Thank you. I'm going to close the public hearing. Bring back the commission. I had a couple of questions here. This letter I got that he sent to Ken Salzar, September 2009. It said that these states, Alaska, California, Colorado, Idaho, Minnesota, Nevada, North Dakota, Oregon, and South Dakota, Utah, and Washington have not done this. Now, are you saying those states have all come on board?
Yes, and in my little FAQs piece, number 8, there, back in June 2008, and I don't know when that letter is dated, but we had that big matrix that I put together of all the states, and it's only the states that have the muzzleloader only season that don't allow scopes. There's other states that do have that allow scopes. They're not affected. So all the states that, including us, have gone through the process. They've gone through the argument of they can hunt in this season, not this one, and they have all developed a reasonable accommodation. So everybody that was named in that discrimination with less last have put together a reasonable accommodation to do that.
Are we going to put a letter of qualification together, just saying what qualifies and what isn't? And is this going to only be issued at the NDOW office? Because like on the DMV, when you go, a lot of people go to Lovelock and places like that to get a driver's license because they're very liberal there, and they don't even pay any attention. So there's a lot of sporting outlets that issue licenses that might just sign this thing off and qualify somebody that's not qualified. So it should be only issued at the NDOW office by your qualified people, and we should develop a letter of qualification. Are we going to do that?
Yes, yes. Conversation, we want to do it at our offices. I don't think you want the...
Right. And in the regulation, it says a licensed agent may not issue a scope permit, and they have to fill out the form that we develop. So I'd be happy to include you in developing the forms because of your professional background. And we do only want to issue it at headquarters.
Yeah, a chicken and egg kind of thing. All the infrastructure, procedural stuff, we didn't want to spend the time and energy to start that yet. We wanted to get the approval through the regulation, and then we'll start on the actual paperwork part of it.
I'm not really happy about it. I don't think a lot of people are, but I learned that I always follow my legal people. And if you're paying big money, woe is you if you don't follow them. But I'm still not sold on it yet. But Commissioner Capurro.
Yes, one last question. I'd like to direct this to Dag, Brian. If one of the requirements we put in here for the issuance of that permit is that he could not hunt, they could not hunt alone, would be that violation of ADA?
Good question. I don't know the answer to that. I would assume that I don't know. Kim's done the research. I would assume that would be reasonable. I don't know.
I would assume nobody else has done it, but.
Like I said, the Colorado Wildlife Agency and the Minnesota Agency have that on their form. How do you plan to retrieve? And they have a requirement where they write out how that plan is. And it's up to the law enforcement. They can ask for additional information. They can ask for a second opinion from a different physician. That's how come we didn't include that in the regulation, so we could. But
that only says that if they shot something and couldn't go get it, they'd have to go back and find somebody. My question is, could, as part of your regulatory requirements, that they have to hunt for someone else? They can't hunt by themselves. Violate ADA.
I have not seen that in any other reasonable accommodations for this issue, and we were trying to just base it on the minimum requirements that they made, and anything the principle was if you don't require a regular hunter to perform some certain task to get a hunting license now, then anything that you would require of a person with a disability might be seen as treating them differently.
This is a special permit.
Yeah.
Just like your blind one is. So the same rules that apply to me and Jerry and anybody else in this room that gets a tag don't apply in this case, because you are providing some what you could call discriminatory provisions to.
My recommendation would be to leave that to a case-by-case basis. And just requiring it up front, anytime you add additional requirements, you run the risk that you're going to get that one guy in the entire world who could hunt by himself with this particular scope, but now you're requiring him to have a second person. So I would recommend against putting that in, just because, like I say, the law books are full of, this will never happen, but then there's that one guy in the entire world that would qualify, and you get him.
I got a question for Brian. Why couldn't we add in there that is not correct by glasses or contacts or surgery? Why couldn't we put that? Because we got a guy walking around that's got a condition like cataracts and could be corrected with surgery, make him a lot safer hunter. Why can't we add that in there and say, then you must have the surgery before we can issue that?
You're going to pay for it?
And I don't know the answer to that. I'll just give you my analysis. If I was the plaintiff's attorney, I walk in and say, you know what, surgery is a very invasive process. There's risks involved with surgery. Now you're requiring me to do surgery before I can hunt, whereas with this reasonable accommodation, I can still hunt. I mean, that would be the argument. Will it fly? I don't know.
Okay, it's the information item. We're about ready to move on. One more. Commissioner McBeth.
Let me just point out that we do this. The track record with Colorado is very limited amount of people are going to do this, okay? And so by doing this, we meet the requirements. It is not going to be we're not going to get a rush, of applicants. We are literally putting in the bare minimum, and to get through this requirement of the ADA, and then we're done. And so we can pick this thing apart, and we can do all kinds of other things to tweak it, but bottom line is we've got a solid, regulation here that is proven through the state of Colorado with one additional change that it's only good for 1 year. So now we have the most restrictive regulation in the country. And I really think that we need to just get this done and move on, because it just is not going to make a material impact on anything else. And if a person has got these kind of issues and goes to this extent to get this scope permit, then by God, they deserve to be able to hunt.
You know, I think you could make them like in a driver's test. If somebody is old and, you know, and there's some visual disabilities, they can require them to do a driver's test. We can require them to do a demonstration, pass a demonstration here, just like the DMV requires them. And I think we can make them demonstrate their ability to handle one power scope and have like a driving test where we can put some requirements on to make them do that. They got to demonstrate that they're not going to be a hazard out in the field, and I think we can do that.
And I would agree we can do all kinds of things, but those things are going to drive additional costs into the process. And what this does is it puts the burden on them to go to a doctor to get the requirements on. So, and then they come in and have to fill out this form, and that's it. And we've already got a proven track record that very few people will do that. Very few number of people will actually apply, and then even fewer will get this. And this is the minimum. We don't have to layer on any more costs, any more involvement, any more administration. This seems nice and clean, meets the requirements of ADA, and we're done.
Okay, you got more comments?
Well, no, I just had a quick comment.
Commissioner Corson.
Thank you, Chairman Lynn. Kim, in any of these states, did they require these disabled hunters, okay, or visually impaired, whatever you want to call them, to have a professional guide? I know Daryl had brought that up, okay, that a person accompanying them, but...
Oh, the only type, like in NRS now, are legally blind license, they have to have someone there. But for this reasonable accommodation, the Fish and Wildlife Service said, these are the minimum requirements, and I didn't see any other states add that on as a requirement, the guide, or to have someone hunt.
Okay, the only reason why I mention that is that my family are cattle ranchers in Colorado, and my father-in-law had turned down a visually impaired hunter. Okay, would not allow him on his, he came in and he went over things with him, and he would not allow him to hunt the land. We didn't get sued or anything like that, okay? But it was up to the ranch owner at that point in time, and he made a decision that that could be a danger to his cattle, his livestock, whatever, and he was turned away.
On private land.
On private.
Right.
Okay, let's move on to the next item, reports.
Mr. Chairman.
Oh, Commissioner Cavan?